Also testifying this week was Anthony Fauci, a man that Judicial Watch has repeatedly focused on because of his important role in the COVID response. He essentially became the most important government official in the response to COVID in terms of being an unelected official. I don't think there's any comparable non-elected government official who exercised so much political power and influence in the during the COVID era. I mean, you probably have to go to military conflicts, World War II or something, to find bureaucrats who've exercised similar types of power in terms of the expanse and influence. But I don't think there's anyone comparable to Fauci in terms of exercising, in my view, virtually unchecked power. And he was excoriated, questioned by the House the other day on all sorts of issues. So let's go to what I thought was the most interesting one first, which was a congressman who's a doctor. I think it's Dr. McCormick from Pennsylvania, had audio of really disturbing words by Dr. Fauci as it relates to vaccine mandates.
I want to point out that I'm probably the only member of Congress that actually treated patients during the pandemic from the very beginning to the very end of the pandemic, during night shifts in the ER. Thousands of patients during that time. I was censored. My medical license was threatened because I disagreed with bureaucrats. Literally taken off the internet as a person who is treating patients with leading edge technologies, developing theories, but doing my very best, but being censored by the United States government for the first time, stepping in and taking the place of medical professionals as the experts in healthcare.
You were going to have schools, universities, and colleges are going to say, you want to come to this college, buddy? You're going to get vaccinated. Lady, you're going to get vaccinated. Yeah. Big corporations like Amazon and Facebook and all of those others are going to say, you want to work for us? You get vaccinated. And it's been proven that when you make it difficult for people in their lives, they lose their ideological bullshit and they get vaccinated.
Are all objections to COVID vaccinations ideological bullshit? Dr. Fauci, you've become Dr. Fear.
The congressman is from Georgia, by the way. I was mistaken in saying he's from Pennsylvania. And but that was the approach. And Dr. McCormick was right in highlighting how what is now accepted analysis of COVID would have gotten you banned from the internet. And any, frankly, criticism of Dr. Fauci got you attacked. Now, I had noticed early on, I'm like, well, this Dr. Fauci seems to know what he's talking about. He seemed relatively sensible. So I wasn't as negative as I probably should have been or could have been early on. But, I take people as they are initially and see what happens. And it was clearly very interesting to me when I saw an email early on in the pandemic that Fauci sent to Hillary, or about Hillary. I don't remember the email specifically, but essentially saying, "We love you, Hillary." And I posted a link to the tweet with my arms crossed. I said, "Very well. Here's the video I posted." Isn't that interesting? Isn't that interesting? So that tweet, can you bring up the actual tweet? Go back to the tweet that actually had the video in it. You can go back online. But anyway, here's what the New York Times reported. They actually covered that tweet. To show the crazed nature of the media's obsession with protecting Fauci, I present to you this loony New York Times piece on my tweet 4 years ago, noting how interesting it was Fauci sent an email praising Hillary. Mr. Fitton at Judicial Watch posted a tweet that showed Dr. Fauci's email and Mrs. Clinton. Fitton included a video of himself crossing his arms and saying, "Isn't that interesting?" it was retreated more than 100, 1,500 times, unquote. Quote. But that's got to be the weirdest New York Times citation of Judicial Watch and me that I've ever seen. And I probably, this is the video again. Isn't that interesting? Isn't that interesting? And the New York Times was describing it in a serious fashion. I mean, that's just beyond. But it shows you how quickly the media wanted to controversialize my little, there's the tweet. Click on the full, March, when was the tweet that I do it? When did I do the tweet? Go back, go up a little bit. March 21st, 2020. Scroll up, let's see what I said in the actual tweet. I didn't even comment on it. Fauci letter to Hillary Clinton surfaces. I don't think the tweet's up on that link anymore. But I didn't even comment on it. I just said, isn't that interesting? That's how sensitive they were about criticism of Dr. Fauci. And once that happened, and that wasn't, I think the Washington Post did a mention of it as well. So these are the two most powerful newspapers in the country, noting that I had issued the most mild analysis possible. Isn't that interesting? His sending an email praising Hillary. Certainly an indication, why isn't it? Why do you think it's interesting? Of course you know why it's interesting. And they circled the wagons around Fauci. And so he's been protected. Part of it was because he was seen as antagonistic and an outsider for Trump. So it was part of this anti-Trump animus. It was during an election year. They wanted someone to make Trump look bad during an election year. That's what the left was planning. And a lot of this COVID mania was about putting people on edge, making it easier to change voting rules, in my view. I testified to Congress about this. In 2020, I saw what was coming. And a lot of the COVID response was nothing but a public health experiment, right? On you and on your children. So when it came to social distancing, there was no science. When it came to masks, there was no science. Certainly for young children, shutdowns, there was no science. In fact, I reviewed what the response plans were for a pandemic early on. And I kept on saying to anyone who would listen in government and publicly, why are you not doing what you said that you would do in the case of a pandemic? Which is, if there are specific instances of transmission, where there's heavy transmission, you do a temporary shutdown. Nowhere in the history of man have you shut down entire societies to control a pandemic. Never has it been done before. And Fauci just threw it all out the window. And when he's testifying the other day and he's asked about this and the masks and such, he said, that was the CDC. When in fact he was the political generalissimo when it came to everything on COVID. Here's Jim Jordan questioning him.
Do you agree that there was a push to downplay the lab leak theory?
Not on my part.
Really?
Really?
Wow.
Wow.
I think most of the country would find that amazing. I still got 11 seconds.
Well, look at the facts. I've kept an open mind throughout the entire process.
All right, I yield back.
And here's something about the masks.
And going back to what I said before, all of that is in the context of, at the time, 4,000 to 5,000
mandates for children under 5, there's scientific evidence for that?
Excuse me?
Mask mandates for children under 5, there's scientific evidence supporting that?
There was no study that did masks on kids before. You couldn't do the study. You had to respond to an epidemic that was killing 4,000 to 5,000 Americans per day.
Non-pharmacological interventions should be studied before they're recommended. Because otherwise, the reason for doing a study isn't to say, thinking, well, this might work. The reason you do studies is not so to make sure not only that it will work, but people won't be harmed by the intervention. So it just can't be, well, let's see what happens. It has to be, let's see and make sure that anything we recommend won't harm people. So when you're telling children they have to be masked, the study has to be sure to reflect that they calculate if there's going to be harms and test for harms. If you're going to shut down schools as an experiment, again, a public health experiment, what are the harms? If you're going to shut down society, what are the harms? That's why I say you were experimented on. And now we know what the harms were. Destruction of our economy, untold deaths due to put off, which was, all of this, by the way, people were saying was going to happen. Generational impacts on student learning. Harm to the public health where people were put off dealing with health issues other than COVID. And then, of course, all the big lies about the vaccine. Yeah, lies. It was suggested it would stop transmission. And as we saw in the beginning of this segment, he didn't care. He just was interested in power. If you were concerned about your health, it was ideological. You were Trump, and you needed to be shut down or forced out of the military like Biden did, or get fired. I mean, remember, Biden wanted to fire people, and the Supreme Court pushed back on that if they weren't vaccinated. And Judicial Watch exposed, our FOIA lawsuits have been second to none in exposing what was going on with the vaccines. That they knew, because the big scam was, and this is what made me curious about the vaccines initially. So what made COVID potentially dangerous were these spike proteins, right? So the vaccine, novel vaccine, stimulated spike protein production. And don't worry, and the spike proteins, we were assured, wouldn't go throughout your body. Get the injection in the arm, and their theory was your lymph nodes here, that's where it essentially would stop. And you'd get the protection and benefits that way. In point of fact, the results, the testing showed that the spike proteins were showing up all over throughout the body. And that's why I was thinking, why is it that we're generating more spike proteins if they're dangerous? Stupid old me, right? What do I know? I'm not a scientist. I got to trust the science. And of course, my instincts were right, and the instincts of a lot of other smart people or kind of dumb people like me, right? I'm joking, I'm not that dumb. But you know, I'm not a scientist. But you know what? As head of Judicial Watch for 26 years, I know a lot about public health. I know a lot about the politics of public health. I know when it came to vaccines that were politically controversial, rules were bent, lies were told, and the people were misled. And COVID wasn't the first time it happened, because Judicial Watch has been doing this for decades. We know what to look for, and sure enough, we found it. And we're taken off the internet, censored, to protect that man and his politics. Now, Marjorie Taylor Greene got some guff because she wasn't terribly congressional in her approach to dealing with Dr. Fauci. I did a video watching a kind of excerpts of the fights she got in and the battle she got in with Fauci and her colleagues on the panel.
Do the American people deserve to be abused like that, Mr. Fauci? Because you're not doctor, you're Mr. Fauci in my few minutes.
Mr. Chairman,
Point of order.
just in terms of the rules of decorum, are we allowed to deny that a doctor is a doctor just because we don't want him to be a doctor?
Yes, because in my time, that man does not deserve to have a license. As a matter of fact, it should be revoked, and he belongs in prison.
That's completely unacceptable to be able to deny Dr. Fauci, who's here, a respected member of the medical community, his title, and that's actually a personal attack on his character.
And I have instructed her.
He's not respected.
And I've instructed her to address him as a doctor.
I'm not addressing him as doctor.
Yeah, I think Fauci should be subject to criminal investigation over this gain-of-function fraud. Did he engage in the fraud? I don't know. Did he know about it? I don't know. But there was fraud, and I want to know who criminally is potentially responsible for it. And there should be an investigation. Now, Judicial Watch uncovered the FBI was looking into gain-of-function and concluded seemingly early on that it was gain-of-function research potentially that created COVID. They were nervous about it. Did they conclude it could create COVID? No. But they concluded that gain-of-function research could develop viruses that would have no evidence that they had been manipulated by human hands. And Fauci, despite his dishonest answers again, that he was not dismissing gain-of-function, that he was not committing perjury when he said they weren't funding gain-of-function, I don't know how else to describe it other than being just misleading. And the legal question is, was it so misleading that it's perjury? I think he needs to be investigated for it. I mean, they were creating, under grants he signed off on, mutant coronaviruses. That's the language in the grant proposal. Mutant coronaviruses. And they poo-pooed the idea that it possibly had lab origins because, in my view, his agency would have been partly responsible if it came from a lab or if it was originated from that lab. Because either viruses the lab was given money to work on, or the technique of gain-of-function that they were being trained on and getting practice with could be used to manipulate other viruses. You know, and gain-of-function needs to be shut down generally. I mean, it highlights why we should be concerned about this debate. It's worth having still, not because of what the Chinese did, that Fauci really played cover for, in my view, based on the documents we've uncovered. But gain-of-function still goes on. It's largely unpoliced. I mean, just because the government doesn't fund it doesn't mean it's not happening. And the government does fund what many consider to be gain-of-function.
Honored to announce that the Supreme Court of the United States agreed with Judicial Watch. We won 7-2 before the High Court on a very important election integrity issue. The question of whether candidates have the right to challenge election rules in federal court, have standing to challenge. In this case, we represent Mike Bost, congressman from Illinois, two presidential electors who technically were federal candidates as well, who are challenging Illinois' law that allowed the counting of ballots that arrived for up to 2 weeks after Election Day. That means ballots could be as late as 14 days after Election Day and still get counted. Now, federal law sets on Election Day, not on Election Week, not on Election Month, but the court didn't want to get at the merits. They said a candidate didn't have standing to challenge this. And they said, well, he was going to win anyway. We're like, well, that's ridiculous because he has a right to an accurate count. He has an inherent right to challenge unlawful election rules on making him, for instance, spend money and time and effort and concern and anxiety related to the counting of ballots that occur after Election Day. And the Supreme Court agreed with us completely and came up and concluded, really affirmed what has been the law prior, frankly, to 2020, that candidates have a broad standing right in federal court. Again, it was 7-2. It was 5 votes in favor of the broadest possible standing, 2 votes in favor of a narrow standing, but pretty broad standing, and then the 2 left-wing justices, Justice Jackson and Justice Sotomayor, filed a dissent. Now, the big majority opinion, the 5, so what happened is Chief Justice Roberts wrote the majority opinion. He was joined by Justice Thomas, Justice Alito, Justice Gorsuch, and Justice Kavanaugh. Concurring in the opinion was Obama appointee Elena Kagan and Justice Barrett. And they agreed that candidates did have the standing to challenge such a rule, but they said they only needed to allege pocketbook injuries, meaning spending money would be enough, or should be the hurdle they have to meet. And Chief Justice Roberts, in his opinion, rejected that in his broad analysis. And this is the way Chief Justice Roberts, I think I got a copy of the way, this is what it looks like when it's published officially. I guess it's white, so you really, maybe I could hold it up against the blue, make it more blue. Can you see it now? Well, I guess you really, it doesn't matter. And I encourage you to read the decision in its entirety. It's available below. We'll provide a link. To start, candidates, Chief Justice Roberts writes for the 5-judge majority, candidates also have an interest in a fair process. Candidates are not common competitors in the economic marketplace. They seek to represent the people, and their interest in that prize cannot be severed from their interest in the electoral process, a process, quote, of the most fundamental significance under our constitutional structure. Win or lose, candidates suffer when the process departs from the law. Thus, the long shot and shoe-in alike would suffer harm if a candidate chose to conduct its election by, say, flipping a coin. The result of such an election would not reflect the will of the people, and the candidates would lose the opportunity to compete for the people's support. So too, similar harms would result from less dramatic departures. For example, if a state decided to discard a random 10% of each vote. Whether these decisions help, hurt, or have no effect on a candidate's electoral prospects, they deprive the candidate of a fair process and an accurate result. So, if there's gaming, potentially, of the way ballots are counted, as our lawsuit alleges for Congressman Bost, the Supreme Court said, yes, you can sue. And contrary to what Justice Barrett and Justice Kagan suggested, you don't need to spend money in order to sue. Because what Chief Justice Roberts wanted to do, and his colleagues, he wanted to be sure that the less courts are figuring out what happened after an election, the better. By suggesting they got to spend money, it means they got to go through the process before maybe a prima facie violation of the law is challenged. I mean, in this case, our client was told he couldn't challenge the law because he won by too many votes. You know, that's absurd. And further in the lawsuit, further in the opinion, I should say, candidates have a concrete and particularized interest in the rules that govern the counting of votes in their elections, regardless whether these rules harm their electoral prospects or increase the cost of their campaigns. Their interest extends to the integrity of elections and the democratic process by which they earn or lose the support of the people they seek to represent. That's a pretty powerful statement. Candidates' interests extend to the integrity of the election. Now, great victory for our team, and that's worth all of the election work Judicial Watch has done to get a result like that. What a tremendous and powerful vindication of all the concerns Judicial Watch and others have had about what we believe to be shenanigans in the way elections have been run. And isn't this decision about 2020 in many respects? Because in 2020, you may remember, when candidates sought to challenge election rules, they were told it's too soon. It's too soon, no harm. Or if it was close to the election, it's too close to the election. Or if it's after the election, it's too late. Here, there's no real question that candidates, assuming there's a valid claim, meaning they make a credible case there's a federal or constitutional issue, a federal statute at issue, or a constitutional violation, they can go into court. And there's no question about the standing. I mean, the idea that someone like President Trump might have the standing, might not have had the standing because he was challenging something too soon, or the challenge may have been incidental to or immaterial to the outcome of the race, that's done. And unfortunately, the court didn't deal with it in 2020, but they're dealing with it right now. So it's a significant victory, and I can't give enough credit to our legal team for getting us here. I can't give enough credit to you, dear supporter, those of you who supported our work, not only prayerfully, but with actual financial contributions to getting this awesome result. And it is an awesome result. This is the statement I issued on behalf of Judicial Watch. This is the most important Supreme Court election law ruling in a generation. Too many courts have denied candidates the standing to challenge unlawful election rules, such as the outrageous ballots that arrive and are counted after Election Day. American citizens concerned about election integrity should celebrate this Supreme Court victory. I thank Judicial Watch's legion of supporters and our election law team that helped achieve this historic result. And of course, Bob Popper leads our election integrity team here. Russ Nobile, also a veteran election lawyer, specifically shepherded this case. And our longtime team member and attorney, Eric Lee, has also been working diligently on these issues as well. And we were aided before the court by Paul Clement, a veteran Supreme Court litigator, and Christine Venson, who's been helping us in Illinois, managing the case there as our local counsel. But I just can't tell you how excited I am, and I guess it really is a remarkable vindication of those of us who were concerned about the way the courts operated in 2020, because essentially Chief Justice Roberts says we mishandled that the courts did not give credence to the rights candidates have to try to settle controversies about the integrity of the election. Now, in some ways, he says, well, this is all about ballot counting, only about ballot counting. Well, you know, that's a lot. You know, pretty much everything elections are disputed over relate to ballot counting. So that gamesmanship where they changed the rules at the last minute and told people they couldn't challenge them until after the election or until after we knew what the impact is, that's not the standard anymore. Now, interestingly, as I noted, 2 justices agreed with the result that candidates had standing to challenge this, what we allege to be illicit counting of late ballots. But Justice Barrett and Justice Kagan said they need to allege a pocketbook injury. And the response that Chief Justice Roberts had, well, that doesn't, it just raises the issue of when judges are going to be able to handle this. Because if there's a legal issue, a candidate shouldn't have to spend money in order to vindicate his right here to have a process that's legal from the get-go. And as he highlighted, some people don't necessarily spend money in campaigns. You get insurgent candidates that are just operating on shoestring budgets practically. And so that doesn't really solve the issue in terms of providing standing to candidates to vindicate our system. Now, the leftist justices, more left, Justice Kagan's pretty left, but not reliably so in certain issues, they issued in what I consider to be a partisan dissent, saying, well, this is just a brand new standing standard. It isn't. And it's going to unleash a deluge of cases. It won't. First of all, it costs money to engage in litigation, so if it's a stupid reason, campaigns don't have the money to engage in stupid litigation. It's got to be litigation that's credible and it's going to have an impact on the campaign in a way to justify the use of precious campaign resources to engage in litigation. And if the litigation isn't credible, courts deal with incredible litigation all the time, and it can be handled appropriately. So that was, to me, not a terribly persuasive, because sometimes dissents raise things that are credible, right? And you got to pay attention to them. Justice Jackson, we may not like her, but sometimes she raises she writes a dissent here and there that makes you think, she has a fair point. So it's important that you read the full decision, and I'll give, to be fair to the other justices, give them give them your full attention as well, and see if it's persuasive to you. But in terms of the law, in terms of the way the law is now applied, our candidate, client, Congressman Bost, is now going to be able to challenge this rule in Illinois. What next? Well, we're in the Supreme Court already on the underlying merits of the issue, whether states can, contrary, we allege, to federal law, count ballots that arrive after Election Day. In Illinois, they count ballots for up to 2 weeks after Election Day, sometimes even without a postmark. We have a challenge there. In California, we had a challenge for Congressman Issa. They count ballots that arrive for up to 2 weeks after Election Day. I talked about this last week. I talked about how 2026 is going to be a big week or a big year for election law because of Judicial Watch. Well, I told you, the Supreme Court just ruled. And now the Mississippi case is before the Supreme Court. By Mississippi, it's called, I think it's called Watson is the shorthand way of calling it. So the Watson case out of Mississippi, we challenged Mississippi's counting of ballots that arrive for up to 5 days after Election Day. And the lower court on the merits said, no, you can't do that. And the Fifth Circuit said, no, counting ballots that arrive after Election Day is unlawful. And so the Supreme Court is going to figure that out one way or the other, we suspect. They wouldn't have taken it up, I think, if they didn't want to decide the question, this term. So right now we're in the middle of the briefing on the issue. We expect the oral argument. I thought it might be in March. It looks like it might be in April now, with a decision by the end of the term, usually by June 30th. So huge developments. And when you look at the majority opinion, it seems to augur well for how the court majority will rule as to whether you can count ballots that arrive after Election Day, which in my view is in plain violation of federal law, which sets an election day. It invites fraud and undermines voter confidence. And I tell you, if the court knocks that out, our elections will, by an exponential way, all of a sudden be more honest, because they won't be having ballots come over the transom through the mail after Election Day to change outcomes. I noted last week, it's worth noting again, there are 2 members of the House of Representatives who are in office as a result of ballots they came in and were counted after Election Day. And they're Democrats. They beat two House Republicans. As far as I'm concerned, the House Republicans would be within their rights to seat the Republicans whose seats were taken from them as a result of this illicit counting. They don't need a Supreme Court decision to judge the election. The House can do it under the Constitution directly. So this late ballot counting matters, is my point. And so to enforce the rule of law, restore voter confidence, and guard against fraud, they've got to set the rule in place or reaffirm the rule. I mean, when you look at all of the amicus briefs that were filed I think there were like 16 or 17. All these leftists are apoplectic about this little scheme being thrown out by the Supreme Court about post-election day counting of ballots that arrive late. So they should be nervous because they know what they're. Because I think they know that we got their number, and I think they're worried the Supreme Court, certainly after reading this decision, may have their number as well. So great work by Judicial Watch. And Russ Nobile, who had been shepherding this case up until the Supreme Court, he made a comment about it just the other day.
Hey everyone, Russell Nobile. I'm one of the election integrity attorneys here at Judicial Watch. A big day for us here at Judicial Watch, whereas the Supreme Court agreed with us and reversed the federal courts in Illinois' decisions, throwing out our election integrity lawsuit there, challenging Illinois' practice of allowing ballots to come in 14 days after election. We're representing Congressman Mike Boss there, along with 2 federal electors. The court in the 7-2 decision basically adopted everything we said and said the courts are wrong to throw out our throw out our lawsuit. The court talked about the different issues as to why federal candidates have standing, and the court ultimately decided it doesn't matter so much whether the candidate's going to win or lose the election. Candidates have an interest in making sure the vote count is accurate, and even if he wins by a large margin, because it costs him more money and causes him problems in making sure the election is run with integrity. And so this is part of a multi-year strategy to get federal courts to finally answer why these ballots are coming in days and weeks after election. We have another case that's pending before the Supreme Court right now. That's a case out of Mississippi that we won in the Fifth Circuit. That case is part of the, will finally presumably answer once and for all why these ballots can come in days and weeks after election. We think this is a really important issue to stop this really sort of banana republic practice of allowing ballots to come in days and weeks after election. Thank you for all of your support, and we'll have more information to come on the cases.
And then here, Congressman Bost, I have to thank him. I mean, it's not easy to get a client, and certainly a sitting member of Congress, to take on a fight like this. So Congressman Bost deserves some kudos for standing in the gap with Judicial Watch as our legal team represented him. He said, "I'm thankful the U.S. Supreme Court has ruled strongly in our favor and concluded we have standing to challenge Illinois' unconstitutional law allowing vote-by-mail ballots to be counted 2 weeks after Election Day. This is a critically important step forward in the fight for election integrity and fair elections. I look forward to continuing to pursue this case as we navigate the next stages of the legal process. It's vitally important that we restore the people's trust in our elections." Amen. Amen. So, thanks to Judicial Watch, it now is going to be easier for federal candidates to stop an election from being stolen. Okay? That's the point of this case. So if they decide to count ballots that shouldn't be counted, contrary to law, a candidate can get into court a lot more easily and stay in court to litigate and vindicate the rule of law and his rights as a candidate. Something that, in my view, was denied improperly to Trump and others in 2020. And that game is no more. That game, the game rules have changed. They changed the rules to keep Trump out, and the Supreme Court fixed the rules to allow similar challenges in the future that have merit. I mean, you're afraid that someone might actually make the merit case that an election has been compromised, and in order to avoid that, you say you can't even be in court to make the case? Well, the court didn't find that to be appropriate, the Supreme Court did, and hence this decision. So great news out of the Supreme Court of the United States. Big news, one of the most important Judicial Watch victories since we've been around 30 plus years. So the other day, Judicial Watch got an inquiry from CNN.
And you may wonder, why is CNN wanting to hear what Judicial Watch has to say? Because they found a speech that Acting Attorney General Todd Blanche gave to a private Judicial Watch event earlier this year. Now, Todd Blanche is up for, has been nominated by President Trump to be the Attorney General. He's currently Acting Attorney General. He's been Acting Attorney General since Pam Bondi left. And so the Senate has to confirm him. And as part of that confirmation process, nominees like Blanche have to turn over every speech they've given. And so I guess he had a record of the speech he gave to Judicial Watch. Now, obviously, I was there for the speech, so I do remember it, but I didn't have the text. So CNN got a hold of it because it's now in the public files up in the Senate, evidently. So the reporter wanted to know, what'd you think about it? And, you know, my first response to the reporter was, well, what did you think about it? And she obviously didn't have much to say. She wanted to hear what I had to say. And my impression of the speech was that it was good that the Deputy Attorney General, the Acting Attorney General, came to see Judicial Watch and make a presentation to Judicial Watch. In many ways, his presence is as important, or was as important, as the substance of his speech. And the substance of his speech was it was interesting. I'll put it at that. So here's the CNN headline. In private speech, Blanche tried to mend fences with critical conservative activists. And that's a reference to yours truly. And the event, the Judicial Watch event, took place at the Doral Hotel, which is run by Trump's family. At President Trump's Miami hotel, Acting Attorney General Todd Blanche recently tried to smooth things over with a conservative watchdog group whose anger at the Trump administration was building on multiple fronts. I don't know if anger is the right term. I'm a friend of President Trump, so I don't get angry about stuff. I sometimes get angry at government malfeasance. I sometimes get angry about government lawlessness. But the challenge we have with any administration, including this administration, is getting them to follow transparency law. That's I wouldn't say the biggest issue in terms of the rule of law for the country. But in terms of what we do, we're asking for Freedom of Information Act records that should be given under law about topics of interest and grave importance to the American people, whether it be the lawfare attacks on President Trump by the Obama-Biden gang, whether it be abuses by Obama against, going back many years to the IRS Tea Party scandal, or Hillary's emails, or the Butler assassination. I've been talking about that recently, the Butler assassination attempt. Or the FBI abuses targeting parents, targeting churches. Anything that you are interested in, Judicial Watch is investigating. And so it's always frustrating, although it's expected because I've been doing this so long, my colleagues and I, that we get the runaround when it comes to getting documents out. But I'm also frustrated by the fact that the Justice Department and the FBI haven't moved fast enough, at least in my view, to prosecute the lawfare and wild abuses of power that nearly destroyed our republic. I mean, this is not a modest or a minor issue. The effort to jail Trump is a republic-ending type of threat to the way our government is set up. It's what separates us from those regimes that we read about in the newspaper where political opponents are regularly jailed. And to have a former president and candidate for president being targeted for jailing and worse. Remember, they wanted to remove his Secret Service protection. And it was retaliation for his First Amendment protected speech, for exercising his duties as President of the United States, and to keep him out of office. And so I think the Justice Department and the FBI have been long compromised by that activity. And however good the head of the agencies are, whether it be Kash Patel, Pam Bondi, or the incoming Todd Blanche, institutionally, the FBI and the Justice Department can't investigate themselves. That's kind of the basic issue I have. But in the meantime, they also have a, I think, grave obligation to pursue or follow the transparency laws and give us the documents as we ask for them. In the private speech delivered to Judicial Watch on April 20th, Blanche attempted to showcase how the Justice Department is addressing allegations of voter fraud and weaponization in the federal government. The group's new leader, I don't know how new I've been here for almost 28 years, has been critical of the Justice Department and FBI. While we may not always agree on every issue, let me say this clearly at the outset. Your mission is not in conflict with the Justice Department I lead. It is a mission the Department of Justice must share, Blanche said, according to his prepared remarks. And as they note, the speech was disclosed to Congress as part of Blanche's required paperwork to be confirmed permanently in his role. So that was a good, I was appreciative of that. I was appreciative, and Judicial Watch's supporters and friends and allies who were there were appreciative of the fact he was present. And there wasn't much for me to argue with in terms of the speech. We hear you, we understand the concerns, and we are acting. And so as he began the speech, he read a few tweets of mine from back in the beginning of the administration. And he goes to the CNN people go, to show how frayed dynamics had become, Blanche read off a string of tweets by Fitton in which he criticized the Justice Department, quote, for hiding records on the Obama gang and deep state abuse of Trump and for protecting the Clintons. And this is what and I'll say it again, I'll tweet this every day till the end of time. The FBI and DOJ must be criminally investigated by someone other than the FBI and DOJ. And I remember he read that tweet, and I'm like, yeah, I agree with me on that, right? So Blanche gave a good speech, and of course he joked a bit about the distance or the criticism. He said, Tom, I thought we were boys. I'd like to think about our relationship as a family. Now that family works together and loves each other, still gets into some spats on Thanksgiving after a few bottles of wine, but it doesn't take away from our love for one another or the common purpose we share. So it's a good speech overall, and it was a good story by CNN in terms of highlighting the attempts of Judicial Watch to try to get the Justice Department to pay attention to these key issues that not only we care about, but I know you care about. How do I know? Because we have hundreds of thousands of Americans who support our work every day. So it's not just, as the headline says, a conservative activist. It's a conservative activist who's the head of America's largest and most effective government watchdog group, the most widely supported group in terms of government watchdog work and transparency in the country, if not the world, which has had the most significant impact on the direction of the country as a result of our historic work. To me, it's no surprise that the acting Attorney General, who was likely at that time to be nominated, all the signs were he was going to be nominated, will come and speak to Judicial Watch. So thank you, Acting Attorney General Blanche, for coming to speak to Judicial Watch. And, my view on what should happen at the Justice Department is, similar to what I've been talking about. They can't investigate themselves. If they are going to do these investigations into lawfare, they've got to get moving on it and be much more aggressive and proactive. Time's a wasting. I don't think the FBI is redeemable. I think the FBI, the Justice Department should be significantly curtailed. It's not so much who's running the agency, but what the reform efforts are. What is the agenda? And the agenda, I think, has got to be much more reformist than it currently is. And that's kind of my general point of view, and you may disagree with it. But there can be no doubt they got to follow the law. There can be no doubt they got to give us the records as the law requires. And that's the challenge, because we're not getting the records timely enough. Now they're trying. Sometimes they're trying. But in the end, it's not much faster than what we got under the Biden administration. I mean, is there a case or two where, oh, maybe we got these records because they recognized it was an important issue and they gave them to us in a timely way? Maybe. I can't think of any offhand. But that happened under the Biden administration too, believe it or not. And we used to get some Biden records without even suing. And that were not flattering to the Biden administration. And here, we can't get records sometimes from the FBI or the Justice Department or other agencies that aren't necessarily about Trump. They're about the abuses of Biden and Obama. I mean, we're still getting... The FBI the other day filed a brief hiding record showing they still didn't want to produce records about St. Hillary of the grand jury, as I affectionately call her. They're still protecting Hillary, this FBI is. So that's the frustration. And I think Todd Blanche recognizes it, and I think they're trying. But you know, we're going to keep on suing, keep on pushing, because that's what you want us to do. I know that's what you want us to do. So you can read the full article below. Now the story was pretty good. It is CNN. I'll tell you a funny thing about the story that I didn't like. They talk about how the nation's top law enforcement officer sought to mend fences with a group that pushed 2020 election conspiracy theories and continues to argue the Trump administration is not going far enough. So I asked the reporter afterwards, what 2020 election conspiracy theories did we push? I don't think, let me check my phone. I will confirm that I haven't gotten an answer yet. Give me a second. Nope, no answer. So they just throw off lines like that are crazy, but that's fine because the story itself is good in the sense that it highlights that Judicial Watch is having an impact, the rule of law matters, and that there are public servants and powerful people in D.C. who are paying attention to what we're doing. And you know, Todd Blanche is certainly someone who sees himself as an ally in our cause, which is good to see, you know. So I can't complain too much, right? Now, tune in next week, and I'll be attacking the Justice Department on topic X, Y, and Z. Don't worry. Thanks for watching. Don't forget to hit that subscribe button and like our video down below.